Hello, everyone. This is Tom Fox, and I would like to welcome you to episode 184 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by Advanced Compliance Solutions. Advanced Compliance Solutions is your one-stop shop for all compliance solutions, including my most recent service offering, the Compliance Retreat. For more information, you can contact me at tfox@tfoxlaw.com, or you can check out my website, Advanced Compliance Solutions. Today I have Marc Bohn. Marc is an attorney with the law firm of Miller and Chevalier in Washington, D.C., and he wrote a very interesting analysis of the Mead Johnson FCPA settlement. He really focused on the lessons learned for the compliance practitioner and how you can utilize the facts of this case going forward. I visit with Marc about the background facts of the case and what he gleaned as the important components for the compliance practitioner going forward. And the lessons are really all the way up from the shop floor to the boardroom. I think you'll find this a very informative podcast. It comes in at just over 24 minutes. Thank you very much for listening. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance and Ethics Report. Today, you are in for a real treat because I have Marc Bohn. Marc is counsel with Miller and Chevalier in Washington, D.C., and he has written one of the most interesting analysis of the Mead Johnson enforcement action that I have seen since it came out. He and I are co-contributors to the FCPA blog, and he posted a blog on it last week. And I was so impressed by his analysis and really the way he looked at it and what it means for the compliance practitioner, the chief compliance officer, and frankly, all the way up to the board of directors going forward. But I asked him if he would come on and tell us a little bit about it, and he graciously took some time from his very busy schedule and is going to visit with us. So with that somewhat long-winded introduction, Marc, thanks a lot.
Thank you. Good to be on.
So this was a case where Mead Johnson got into trouble in China. And why don't you kind of pick it up with the facts from there, Marc?
Sure. As set forth in the SEC's order, this company, Mead Johnson, had a compliance program in place, had been in China for a couple of decades, but since 2008 really experienced some explosive growth in the area. From, I think the SEC order states they went from being in 28 cities to 241 over a period of 5 years. Anyhow, the SEC's investigation, or the SEC order, alleges that Mead Johnson employees in China funded improper payments in the country through its distributors, through its third-party distributors who market, sell, and distribute the baby formula product for the company. And they had a distributor allowance that was set aside for marketing that the company still had strings attached to. So once this allowance was provided, the company would track its use and direct distributors allegedly to provide it to hospital employees, nurses, doctors, healthcare professionals, for contact information relating to new or expectant mothers, or to recommend or push the company's product on patients. So as an improper means of marketing the product. So those are the allegations, and there's some substantial amounts involved. I think there was over $2 million in improper payments or improperly distributor allowances provided, and the company allegedly received almost $7.8 million in illicit profits as a result.
Now, Marc, you're a white-collar defense lawyer practitioner at Miller in Washington, D.C., and you've been doing this for quite a while, and certainly you and I have both seen enforcement actions and various bribery schemes that have come up, and certainly this one was interesting and perhaps even creative. But that's really not the focus of why I think this enforcement action was so interesting. There was a 2011 investigation, and why don't you pick it up there with it was an internal investigation. Why don't you pick it up there with what the company found out and what their response was?
Sure, and I agree. I mean, there's all these cases to me are interesting, but as a matter of course, this is fairly standard. There have been several healthcare-related actions that have had bribes to in the form of discounts to distributors as a means of providing benefits improperly to officials. What's interesting in this case is Mead Johnson had a compliance program in place per the SEC order, and they had a system for receiving allegations and processing them, and they received allegations of that this program was tainted, and they conducted an investigation in 2011. What they weren't able to do per the order is they failed to identify any improper payments, but the investigation clearly identified risk because the company, as a risk preventative measure, decided even though they couldn't identify any improper payments to healthcare professionals, they were going to go ahead and shut the program down anyhow. And they did that, and actually by the time this SEC order came out, this resolution came around, by the time the SEC initiated its investigation, in 2013, they had actually shut the program down and were no longer providing these benefits.
So that brought us up to 2013, and what you detail I find not only very interesting but also very instructive, and lots of lessons learned for the compliance practitioner just in what you described. But I think you and I were both sort of at wonder at really how the investigation went from there. What happened when the SEC came knocking? So why don't you fast forward to 2013 and bring us home?
Right. Well, that's one of the risk areas now is anytime you have an internal issue come up, compliance officers have to field a range of legitimate complaints or legitimate allegations with false allegations or allegations that are trumped up by, maybe employees that feel they've been aggrieved, and so they have to sort through all of this. And if they don't handle an allegation correctly, there's always the risk that the whistleblower may turn around and go to the SEC. There's the new whistleblower bounty program under Dodd-Frank, and companies have to give thought as to how they handle allegations and how they communicate with whistleblowers and how they effectively handle the risk in this area. In 2013, the SEC approached the company. They had learned of these allegations. The SEC order does not say how. One can assume possibly a whistleblower, or maybe there was a civil action, antitrust action, or whatnot in China. There's a range of ways in which the government learns about these sorts of allegations, and they do track the prosecutions of foreign enforcement authorities for a range of reasons. And if they see something that looks suspect, they may kind of tug on that string a little. But in 2013, they approached the company, and the company seemed to be caught flat-footed. It's unclear whether it was a conscious, deliberate choice or whether it simply was a defective organization, but they did not inform the SEC that they had previously looked into this matter, and it doesn't seem as though they were kind of initially prepared to respond. And then as the SEC continued making inquiries and the company cooperated and ended up providing full cooperation, and it came out that this prior investigation had been conducted and no improper payments had been identified through it. But I think the SEC, it was a 1-2 punch. The SEC feels as though companies, if allegations are significant enough, they should be voluntarily disclosing these allegations. There's nothing statutorily that obligates a company to do so, but if you want to receive cooperation credit, the full amount from the authorities, then you need to consider that when significant allegations come up. But then not only that, they were not prepared to respond. So my guess is that, they probably organizationally, maybe there was turnover, who knows, but they just weren't prepared to identify this as the same allegation, and they learned of it later and kind of said, wait, we already looked into this, and informed the SEC after the fact, which probably annoyed the SEC.
Let me focus on the issue of self-disclosure, because I think that's not only certainly important, but it's one that companies, lawyers, compliance practitioners, everyone involved, from the shop floor, frankly, to the boardroom, struggle with. And the thing that struck me about this case was many in the commentariat that this was pointing us down the road to mandatory self-disclosure. Now, clearly you pointed out that mandatory self-disclosure is not required under the FCPA or any statute around anti-corruption in the United States. Do you have any thoughts one way or the other of where the SEC may be going, or is this just sort of their continued campaign to always suggest companies self-disclose?
I mean, the SEC is going to urge a company to lean towards disclosure in all instances, or in most instances. I mean, there's obviously been comments from DOJ and SEC officials that have stated that, I mean, you don't need to disclose everything, that if you have a solid compliance program in place and something minor comes up and you handle it in course, that just document it well and be prepared to discuss it later if something ever comes up. But in this case, I mean, you had prolonged conduct. I mean, this is misconduct that went on for 5 years, and you had millions of dollars in alleged improper payments. It wasn't a one-time thing. So I think when there's systemic issues, the SEC may feel there's a stronger case for voluntary disclosure. I'll tell you, our clients, I mean, they give a lot of thought to this, and if they do not decide to voluntarily disclose a particular matter, I mean, we always recommend that, I mean, they make up for that by conducting a very defensible, well-documented investigation that would uncover the same stones the SEC or DOJ would ask them to, and documents what they found and documents their response to this. And it actually, I mean, in this instance, doesn't seem like Mead Johnson did a terrible job. I mean, I'll tell you, from doing investigations in China, it can be difficult to discover the purpose behind improper payments. You'll advise a company that has employees that are falsifying events or doing other things of that nature in order to generate funds that they do something with, but it's not always clear whether it's for personal enrichment or whether it's to make improper payments to a healthcare professional. And so often, I mean, if you discover the scheme that's generating the funds, if you can't discover where the funds are going, you shut the scheme down and you discipline the employee and you make changes. Your compliance program should be seen as evolving. And in this instance, Mead Johnson conducted an investigation and shut the scheme down. What may be lacking, though, is they may not have made the compliance improvements necessary and may not have responded appropriately on a remediation front. Simply stopping something without getting to the root of the misconduct, which may be employees, which may be a lack of internal communication, which may be, training, which may be a lack of resources, is going to be frowned on by the agencies. And here, Mead Johnson, in cooperating, clearly undertook significant remediation, instituting a function within China to provide ongoing monitoring, terminating senior employees, enhancing controls and policies. So maybe some of those things that they did in response to this action, if they had done earlier and they had been prepared to respond to the SEC when they came knocking, we may not even be looking at an enforcement action.
When I read this enforcement action, I really thought about this through the eyes of a CCO or a compliance practitioner. But after I read your blog post, I really thought you gave information which I thought the board of directors needed to hear. And that was, what do I consider in the decision to self-disclose or not? And you ticked off several of those things just in your last remarks. You talked about the systemic conduct. You talked about the length of time it had occurred. You talked about the amount of bribes paid. And really, I've not heard someone kind of articulate those sorts of things. Could you maybe walk us through some of the things you and your firm might talk to a board about, and just helping them make that decision or putting the facts in front of them?
Right. I mean, in part, it's you have to step into the shoes of a prosecutor, and I mean, how would a prosecutor react to the information here? In this instance, I mean, I don't know that the decision not to disclose was necessarily a bad one had they done all the other things they needed to do, but you need to consider how this is going to look if it comes out, and you need to consider the size of payments involved, the scope of the misconduct, how senior the officials the employees involved were. How far up the ladder does it go? The further up the ladder it goes, the larger the scheme, the more systemic the issue, the more that the agencies are going to see this as something that should have been voluntarily disclosed.
If I could read a paragraph from your, I probably should tell the name of your article. It was Mead Johnson's Lessons Learned About Enforcement Practices and Expectations, which was posted on the FCPA blog on July 31st. But near the end, you had a paragraph which said, investigations which lack sufficient depth, resources, or forethought can pose significant risk because they increase the likelihood that something critical will be overlooked, potentially permitting misconduct to continue unabated. This may also give the appearance that a company is not truly committed to compliance or is more concerned with sweeping misconduct under the rug. Not a lot of people really think about what are sufficient resources, what is sufficient depth, what is sufficient forethought. I recognize that in many ways this may sound more art than science, but how do you help a company understand really what would be sufficient depth in this sort of situation?
Right. Well, I think identifying employees involved, identifying to the extent possible where improper payments or where funds or slush that appears to be generated is going, conducting interviews. So I think in this instance, had a client like this come to us, we would have recommended to put some resources on the ground to come in and to interview employees and to do forensic analysis and see if you cannot identify where the funds are going. It's a substantial amount of money. That doesn't mean you have to boil the ocean, but you need to look and take steps that are likely to identify where the improper payments are going, who was involved in the scheme, who had knowledge, things of that nature. And in part, that's not only because you want to identify the specific misconduct here, who's responsible for it, but you want to identify weaknesses in your program. And employees, particularly in a place like China, in some senses it's whack-a-mole, and the government knows that. And we've represented numerous clients that have ultimately never been charged but have encountered issues in China, but they've been able to show that their compliance program was nimble enough to respond to issues when they came up. And so when issues come up, one question is to say, are we likely to get a response? So here, a company may have determined that they're going to stop short of going and interviewing the distributor involved or a specific distributor because they're not likely to get a straight answer from the distributor. It's going to probably be a waste of time. So instead, they're just going to terminate the distributor, but they're going to tighten up their controls on how they vet distributors in the future. And so those are the types of decisions you weigh how deep to go and whether an additional step makes sense. And sometimes you may say the amount that would cost is significant and it's not likely to produce a great deal of information, whereas conducting an email review of the files from an implicated employee or having a forensic auditor go through your books to kind of identify the scope of the misconduct, those are likely to produce relevant information that is very actionable and are probably kind of seen as a minimum that you need to do in response to something like this. So it is case by case, but you want to do enough digging that you can identify kind of the bad roots and any bad eggs within your organization and any holes in your compliance program, and then turn around and respond to those. In this instance, it's not clear that Mead's compliance program kept pace with its growth in the region. So it may have had a defensible compliance program when it was in 28 cities, but if the number of compliance personnel that it has available to assist and the scope of its controls, et cetera, did not grow with the company's business, which grew by 1,000% in that period, they expanded 241 cities, then the compliance personnel they had that were sufficiently meeting the needs of 28 cities are probably not going to be meeting the needs of 241 cities.
Yeah, it's a really important point, and you've said it several times, but I'm glad you've said it several times. which is your compliance function needs to grow with the business. And when you have that sort of explosive growth, many times compliance is running in place, trying to catch up, and unfortunately doing so more slowly than they need to. Marc, in another part of the article, you talk about some of what you call the other noteworthy aspects of the settlement, and I'd like to just explore those a little bit in our time remaining. You certainly point to China and how the number of enforcement actions in China, but you also point to this as the second China-related healthcare action since the GSK investigation of July 2013. Do you see this as perhaps presaging a stream of China-related enforcement actions in the coming year or so?
Well, I mean, it's difficult to predict when specific enforcement actions are going to wrap up, but given the typical life cycle of an enforcement action, we knew that there were a number of companies at the time GSK broke open that were then under investigation, and those investigations have continued. Typically, when an investigation lasts several years, you expect there's probably going to be some enforcement action of some sort taken. So I do think it's likely we're going to be seeing more and more not only China-related enforcement actions, but healthcare-related enforcement actions in China. I know that, I mean, we've represented companies that, following GSK, were approached by the agencies again and asked. I mean, part of what the SEC does is they look for patterns, and if they identify one company in an area doing something, they'll go to other companies in that area that may be under investigation and ask, look, I mean, are you doing the same thing, and look for patterns that they can try to put an end to. And it may be that other companies, I'm assuming GSK was not the only company that was doing the things that it was doing, and some of those inquiries by the SEC may have led to other companies getting it deeper in the hole. So I think it's likely we're going to see in the next year, in the next coming years, just a continued trickle of cases from China on the healthcare front.
And I'd like to end with a really interesting note you had in the same section where you talked about the length of time from initial SEC inquiry to resolution. And when I say length of time, I actually mean the shortness of it. This one seemed to be a little more quickly handled than a lot of other investigations. What has the firm's work, particularly around the summer report, shown in terms of the length of investigations, or summer review, I should say?
Right. I mean, the last time we did a full, we need to update our analysis, but the last time we did it a year or two back, the average length of an investigation, I think, was a little over 3 years, and a great number of investigations lasted longer than that. If an investigation wraps up in 6 months to 2 years, it's pretty quick. And in this instance, I think it may speak to the fact that Mead Johnson had what seems like a solid compliance program in place. It just wasn't nimble and didn't adapt or evolve, and they didn't fail. They failed to adapt to evolving risk. But I mean, Mead Johnson's penalty was the ratio of penalty they paid per dollar of profit was higher than several recent cases. But on the other end, they didn't have a compliance monitor or consultant or imposed, as had several other investigations. All of them, many of them SEC only, but Goodyear had I think a 3-year self-monitoring. So for 3 years, they were going to continue to report to the SEC on the status of their compliance program. Here, the SEC felt comfortable enough with Mead's program and the changes made to Mead's program that it didn't require them to self-monitor or report for the coming years, but they did impose a slightly higher penalty than they have in recent cases. So they part of the reason I think that the Mead Johnson case wrapped up quickly, to answer your original question, I think maybe the fact that it had a decent compliance program in place that simply needed to be updated.
Well, Marc, unfortunately, we're near the end of our time, but I really want to thank you. This has been an incredibly informative podcast, and I would point people to your blog post of July 31 on the FCPA blog. But I also wanted to ask if listeners wanted to follow up with you directly, could they email you at the firm, and if so, how?
Yeah, they're happy to. Or I mean, they're welcome to. I'm happy to respond to any inquiries anyone has. My biography is available online. If you go to the FCPA blog, I'm off to the side there. My email address is mbohn@milchev, milchev.com, and I've got my phone number on my website as well. So anyone who has questions, feel free to follow up.
Well, Marc, I really appreciate you taking the time to visit with us. This has really been informative, and I think this may be the first of several conversations going forward.
Hey, it was great to talk to you, Tom.
Thank you.
Take care.
Hello, everyone. This is Tom Fox again, and I hope you enjoyed this episode of the FCPA Compliance and Ethics Report. I have 2 calls of action for you. The first is to please go to iTunes and rate this podcast. The second thing I would ask you to do is I'm preparing my next mailbag episode, and so if you have any questions, please shoot me them in an email and I'll answer them here in the next mailbag episode. I hope you enjoyed this episode, and thank you very much for listening.